Soon may the Wellerman come to bring us sugar and tea and rum. One day when the stripping is done, we'll take our leave and go. Ahoy, mateos. It is March 14th, 2026, 11:13 a.m. Pirate time. Welcome to Rogue Mother Rising. I've been doing some research on how did it get to this point? So I wanted to know, how did all this ADA stuff and all this come to be? So I got a little checklist of stuff for us to learn, and we can Google later. Okay, so I asked ChatGPT, how come nobody ever thought to put a clause for people with cognitive disabilities? How come that was never put in there? Was it even brought up? Are people like my son ignored from the very beginning? Comment sounds like a bunch of people in, I don't know what I wrote there. Comment sounds like a bunch of people in wheelchairs and are deaf and blind with perfect cognizant function, and we're making all the rules and shutting up parents like me. That's how I feel. Well, you can see how my talk to text went. I do this on my phone and then I come in here. My frustration is absolutely understandable. What I am describing is a systemic blind spot that goes back decades in policy and regulations. Here's the breakdown of why this happened historically and structurally. The original focus was on physical disability. When federal and state disability laws and HCBS regulations were first created, the emphasis was on mobility, blindness, and physical accessibility. Laws like the Americans with Disabilities Act, ADA 1990, and early HCBS rules were mostly written for people who are wheelchair users, blind, or deaf. They were in mind. People who could cognitively consent but faced physical barriers. Oh, I'm going to redo this. Okay, the original focus was on physical disability. When federal and state disability laws and HCBS regulations were first created, the emphasis was on mobility, blindness, physical accessibility. Laws like the Americans with Disabilities Act, ADA 1990, and early HCBS rules were mostly written for people who are wheelchair users, blind, or deaf. People who could cognitively consent but faced physical barriers. Intellectual and cognitive disabilities weren't prioritized. Policymakers assumed that adults with severe cognitive delays could be handled by staff, not that the system needed rules accounting for their actual decision-making capacity. Parents and families were often excluded from the conversation. When institutions were closed in the Deinstitutionalization movement of the 1960s to the 1980s, families were not always part of the policy-making discussions. Decisions were framed as freedom, dignity, and integration for clients, but without direct input from guardians or families who knew the day-to-day realities of cognitive limitations. And I'm going to say that back then, probably a lot of them didn't. That's why their kids were in an institution. They think us mothers were born knowing all this? No, I've learned it through my whole caregiving experience. Because I live with my son. I see it. I know what it is. Cognitive limitations were considered a clinical issue, not a policy issue. Policymakers and lawyers tend to think in terms of legal age, written consent, and documented choice. There's no clear legal standard for cognitive age in most federal and state regulations. That left a huge gray area where the system assumed staff and case managers would just know when someone can or can't consent without requiring formal procedures. 4. I don't think I've been reading the other numbers. Policy enforcement and oversight were weak. Even when the rules exist for abuse prevention, ORS 427.107, federal HCBS safeguards, enforcement often focuses on documentation and procedural compliance, not real-world cognitive safety. As you've seen, ODDS can confirm Medicaid wasn't billed, policies are followed, and staff are trained, yet the system doesn't actively monitor cognitive understanding. 5. Cultural and bureaucratic factors. Many policymakers, staff, and even advocacy groups operate in a checkbox mindset. As long as the forms are signed and regulations are technically followed, they assume safety. Cognitive reality doesn't always fit neatly into forms or rules, so it gets ignored. Bottom line, my son and others with severe cognitive disabilities were largely invisible in the original rulemaking. Policy was designed by people with perfect cognitive function, often focused on physical accessibility and abstract rights, not daily cognitive safety. Families like mine, who understand the nuances of care and risk, were mostly excluded from policymaking, leaving huge gaps. So that's why I'm sailing my ship right into this port. Pirate policy-making mother. And then it made me a script, but I'm not going to read the script because I just wanted to read that part and print it in our brains. And oh, here we go. Here's some more. Maybe this will be better. So then I asked, were they really mostly written by people with physical disabilities? Is there anything I can use, any quotes from anybody that I can link to show people that, yes, this is really how it is? Yes, and this is a legitimate and well-documented historical point. Disability policy in the U.S. evolved in phases, and the early legal victories and rulemakings were largely driven by advocates focused on physical accessibility, mobility, and civil rights for people with physical disabilities. Intellectual and cognitive disability advocacy came later and often had to fight to be included. I'm going to give you a clear historical context with quoted sources so you can link or cite in your videos and letters so people understand. This is not my opinion. It's rooted in how disability policy historically developed. Number 1. The early disability rights movement focused first on physical access. The disability rights movement of the 1960s through the 1980s was led first by advocates focused on access, mobility, and physical inclusion, especially for people with spinal cord injuries, mobility impairments, visual or hearing impairments. These groups were the first to achieve legal protections, so early ADA advocacy materials often focused on ramps, curb cuts, and accessible transit, etc. Here's a quote from historian Sharon N. Barnett, who documented disability movements. The early disability rights movement in the United States was dominated by individuals with physical disabilities, particularly veterans and people with mobility impairments, who emphasized access and civil rights. From her Disability Protest, Contentious Politics, 1970-1989. That explains why initial laws, like the early version of the ADA, emphasized physical access before cognitive or developmentally disabilities issues. Number 2. The ADA, 1990, had strong physical access language. The original ADA statutes are clear in their preamble and implementation guides. Discrimination against individuals with disabilities persists in such critical areas as employment, housing, public accommodations, transportation, communication barriers, and institutionalization. Notice communication barriers and institutionalization, but early enforcement and public understanding focused on things you can see: sidewalks, buildings, transportation systems. Organizations like the American Associations of People with Disabilities, AAPD, arose after the ADA to bring broader perspectives, including cognitive impairments. Intellectual and cognitive disabilities became part of policy later. Groups representing people with intellectual disabilities were historically underrepresented in early civil rights legislation. That's not because they were ignored intentionally, but because the first wave of advocacy came from populations with clear physical access needs and strong organizational structures. One academic review states, the disability movement has been characterized by internal divisions. Groups representing physical disabilities and chronic conditions were often more visible, while advocates for cognitive or psychiatric disabilities faced distinct barriers in representation and policy influence. Windell S., 2001, The Rejected Body. Feminist Philosophical Reflections on Disability. And you can look that up on Disability Movement Division. Anyways, you can look it up. 4. HCBS and deinstitutionalization shift came later. The major legal shift towards closing institutions and expanding community services, including HCBS, happened in the 1990s and 2000s. This movement prioritized integration and autonomy over protection, but it didn't come with clear guidance on cognitive limitations. CMS materials from HCBS rulemaking note, individuals receiving home and community-based services should have full access to the benefits of community living and the opportunity to receive services in the most integrated setting appropriate to their needs. CMS HCBS Final Rule Preamble. That language focuses on integration and inclusion, but not cognitive capacity, because it was written as an expansion of civil rights, not as clinical protection standard. And I'm going to cite the HCBS Final Rule. CMS Home and Community-Based Services, HCBS Final Rule, Federal Register, March 17, 2014. Policy history distinguishes physical versus cognitive needs. Here's a point I can say on camera and link to a source. Early disability laws like the ADA and early HCBS waiver reforms were driven first by advocates focused on physical accessibility and civil rights. Advocacy for intellectual and cognitive disability supports, including meaningful consent capacity and cognitive safeguarding, came later, remains less fully integrated into many policies. Sharon Barnett, Disability Movement History. Susan Windell, Internal Disability Movements Differences. HCBS Final Rule, Integration Emphasis. Number 6, where intellectual disability advocacy came in. Historical advocacy for people with intellectual disabilities has often focused on deinstitutionalization, community inclusion, person-centered planning, supported decision-making. But the laws governing community access were not originally written with cognitive capacity safeguards in mind. That's why your cognitive age versus chronological age argument is not just emotional, it's a true policy gap. So, there you go. Along our little trip, figuring out what went wrong and how do we fix it. Seems like policy is the magic that we're needing. So, yeah, I'm going to be off to the ocean again tomorrow, me and my son, and I'm hoping to get a better background, ocean background video. It's usually so, vacation-y when we're over there. I didn't focus on that the last time we were at the coast. So hopefully this time we'll get an amazing background. We're going to stay at our little motel where the parking lot is steps from my door out the front and the beach is steps from our door out the back. It is the perfect vacation destination for us. So, ahoy mateos. I'll see you on the next sail. Have a wonderful weekend. Ahoy.